but that goes to the temperament of the trial counsel. So you just have to kind of make friends before you go, but realize that, you know, depending on the temperament of the trial counsel involved and the judge, who probably likes that trial counsel and doesn't like the fact that you're coming to raise ineffective assistance of counsel with them, that, you know, you just act professional and then you move on. You get what you need.
I think that's a good observation. I was challenged in a vehicular homicide that I tried, and lawyers from the Brunswick area, which is down in South Georgia, and he got a conflict appeal from the Standards Council, and he called me up, was very pleasant, said, look, I want to look at this, you know, I might have to allege this, and I said, fine. You know, I think the fact that he made a phone call and just talked to me about it made all the difference in the world to me. And you're right, at least down our way, you know, they all fear Atlanta lawyers. And of course, an Atlanta lawyer is defined as any lawyer who practices north of Macon. That's the way it's viewed. And what I would suggest is make contact with the lawyer if you are going to make an effective claim. You can sometimes gauge the temperament of that lawyer, how they're going to respond to it. Assume for the sake of argument that that lawyer is hostile to you. I'd make a call to the circuit public defender, because we support everything that y'all are doing and are glad you're doing it. And like in my circuit, for example, I think for the most part, if I had a defense lawyer who was upset about that I could say, look, you know, give the guy a break. He's got a job to do, and it's a tough job. And I think for the most part, they'd cooperate. So I'd say, try to be professional with the lawyer and the district attorney, and then make a call to the CPD if you think there's a problem. And usually, most CPDs will try to smooth the way for you.
Obviously, that's what I was saying. When you call them up, you don't say, I just screwed up. You call them up and you say, can you talk, what do you think would be some decent avenues of appeal? When you call, be sensitive to just what they just perfectly described, what you were coming across as. And if you're coming in solicitous of their thoughts, they may come to that for you. You don't have to have the fight. Say, at the end of the day, after all these, here's some places where you may have ineffective assistance. But start out with, what angles do you think we have on the appeal of this case? And working from there, build a relationship, build a conversation with them on that issue. And then, having built that, if you need to, move over to the ineffective assistance issues.
And that's not just a matter of tactics in relating to the trial counsel. I mean, one of the most useful ways you can spend 15 minutes starting out and working on the appeal is ask the trial lawyer what they think.
Jim, did you want to get on this?
Just briefly, the Bullitt County or the South Georgia scenario is part of what we do is we have a statewide system. But I would say that the bulk of the cases that come to us, as you might expect, the bulk of the trials are really in Atlanta, in the Atlanta area. There are other pockets where there are trials of cases, Augusta, or your larger mid-major metropolitan areas in the state. Rural areas have some, but the bulk of this work will likely be from the metropolitan Atlanta area. That doesn't mean that counsel is going to be nicer to you, but maybe there won't be quite the judgment of Atlanta lawyer being north of the gnat line, as we say. But that doesn't mean there won't be cases in other parts of the state. And a lot of the cases are actually public defender handled. I mean, most of them are going to be handled by the circuit public defender offices. And you met Robert; he's a perfectly reasonable guy, and there'll be other circuit public defenders throughout the state who are. And dedicated criminal defense lawyers, professional criminal defense lawyers, very often are the ones that are most likely to talk to you about their cases. There'll be some of these cases would be tried by private attorneys, and you'll have varying ranges of attitudes about or from the folks that tried the cases. But I don't want you to be overly discouraged by the thought that you're going to get necessarily negative feedback, and that a lot of these cases are going to be in unfamiliar parts of the state. So just as some judgment on that.
Yes, ma'am.
I'm getting the sense that the issue of ineffective assistance of counsel is something that gets raised in the vast majority of cases. Is that right?
I think it is.
Yeah.
I had one assistant DA tell me one day, he says, all I deal with on motion for new trials and appeals these days is ineffective.
Well, I know how I would feel if someone claimed that I was ineffective or that I had screwed up. You know, I would really, really be hostile to that. Is there a different culture in the criminal defense bar that you kind of go wink, wink? Or are you a bunch of incompetents or what? I'm just stunned.
I'm not answering that, Jim.
I mean, is it something we've just agreed that we'll get to raise it?
I can address your question. Having practiced criminal defense for 18 years, I sort of divided into categories. The vast majority of us are in the category I call true believers, which is we practice client-centered criminal defense. And at the end of the day, our practice is about a human being who may be spending a long time in prison because of what's happened. And it might be because somebody made a mistake. And we all are human. We all make mistakes. And we try to instill in our lawyers in the public defender's office in the Atlanta Judicial Circuit the idea that, you know, if you make a mistake, it's okay. The important thing is to own up to it. Because at the end of the day, it's the client who's going to be suffering the result of that mistake. And so I can say almost without exception, the lawyers in our office, their encounter, it's sort of part of the job, it's part of the culprit. If you're encountered with a claim of ineffective assistance of counsel, go into court, you documented your file, you explain what you did. You don't get defensive about it. And it's just a completely different mindset. And I think the vast majority of that stems from the fact that perhaps in civil practice, if you mess up bad, there's a financial penalty to be paid. Okay? In criminal practice, if you mess up, even if you're ineffective, there's only a couple of situations where that can result in a malpractice claim that's going to have a financial judgment attached to it.
It doesn't affect your malpractice rates?
No, we're covered by the county.
That just blows me away.
Criminal malpractice
It's-
rates are like the lowest I think you can get, because nobody gets sued.
I think a professional who's, and I've certainly been on the receiving end of claims of ineffective assistance. And I think a professional attorney handles themselves professionally, and they understand that the appellate attorney coming in is doing their job and reviewing their work. And trials happen in the heat of battle. And I think any professional attorney is and should be willing to comport themselves professionally when they're accused of ineffective assistance and be honest about it.
Cindy?
I was just going to add that really, I mean, a lot of these cases aren't being handled by public, or were handled by public defenders. So the way I kind of approach it is, I mean, they have crushing caseloads. I mean, we're talking about a set amount of time for each case that they have to prepare for. So then it goes to the amount of preparation and then whatever oversight that they may have made. And it doesn't go towards any incompetence. It's just, you know, they just didn't, you know, either consider this or just overlooked it. And so that's how I approach it when I'm raising ineffective. But what I was also going to say is, a lot of times you're not going to have the trial court grant your motion for new trial based on being ineffective. So you're really just establishing the record. And so if you just kind of keep that in mind, I had a Fulton County judge actually on the bench start saying that, I can't believe you're alleging ineffective. This is the best trial lawyer I've ever encountered. She's won many cases, blah, blah, blah. And I'm like, okay, well, I'm trying to say that she was ineffective in this case, and I'm trying to establish a record so that either the Court of Appeals or the Supreme Court will get to see the record and see what the error, what error was made, and whether it was harmful enough to rise to the level of ineffectiveness of counsel.
Gerard?
Hey, my name's Gerard, and I have been found ineffective by...
Gerard has established the law in a lot of areas.
I've been found ineffective by the DeKalb County Superior Court. I have been found ineffective by the Supreme Court of Georgia. It is, I think most lawyers know that the best lawyer in the world can be ineffective. And especially, I think if you do trial work, I mean, you just got to know you're going to be ineffective. ineffective. I mean, you just can't keep up and be on the game, you know, the entire time. You're gonna make a mistake. Everybody makes a mistake. And the best lawyers in the world can make mistakes, and you'll find case law that says that, which, you know, you need to use when you run into what Cindy ran into. But most criminal defense lawyers, I think the tone of this, we've been talking a lot about difficult lawyers. I've had a couple difficult lawyers. I've had 2 lawyers that refused to respond to subpoenas. And eventually, you know, the hearing gets reset, the judge orders them to get their butt in court. But for the vast majority aren't gonna fight you tooth and nail. They may not say good things on the stand, but the vast majority of lawyers, of criminal defense lawyers, understand that, you know, it's a difficult process. There are a million objections you can miss, and that they might have missed them.
How many cases do you try here as a public defender? Approximately.
Surprisingly fewer than I would have thought. I mean, it's been a long time since I've done trials, but it was just, I think the most I ever tried was maybe 6 a year.
Husband's on trial, either in court with cases that are supposed to be ready for trial 2 weeks out of a month easily. I mean, trying to get a case possible. So you're constantly ready for trial on any number of dozens of cases, many of which are pretty sick murders, armed robberies, rapes. You're constantly being called in by the judge who wants to move their caseload. And so you've got to be ready on many, many cases every week.
So my thought was, to Judy's point, I mean, us in the private bar, we don't try that many cases in a year, and maybe it's the crutch of caseload that sort of keeps you in that pool, you know, having some ineffective moments.
Yeah, but also it's just a matter of reality. Everything's not gonna be perfect.
Right.
And I guess maybe when I see how ineffective counsel is defined and what would win a case and what wouldn't win a case, I might feel better, but otherwise, my heart goes out to criminal defense lawyers. I feel like we're letting them be slaughtered here. And now we're gonna be part of the slaughtering process.
Jim?
And I guess one way I can think of it is, it's almost an indictment of the indigent criminal defense system, that if we gave adequate funding for this, there wouldn't be these crushing caseloads. But it hurts me as a lawyer to go pointing fingers at other lawyers and say they're ineffective when it's just part of the process of trying a case, that you can't be perfect.
Well, think about every civil case where you have read in the Court of Appeals decision that the appellant waived that issue because they didn't do something. That happens actually in a lot of civil cases. Doesn't result in malpractice usually. But in the context of the criminal case, you've got an ineffective assistance often associated with that. So it's not so unusual even in the civil context.
Gerard, before Jim wanted to get.
Let Gerard first.
Okay.
Oh, okay. Well, I was just gonna say, in Gerard's defense, having confessed to being held ineffective, Gerard is the last person to reverse the Georgia Supreme Court and the Supreme Court. So it's not, he's gotten even. He did the Presley case recently that came out of DeKalb. But what I was gonna say, Judy, we're many minutes from your original question, and you asked about what is it a culture thing or something like that. I am renowned for my soapbox that I erect on this damnable Garland case, which is the reason that most of these conflicts have gotten here. And essentially, Gerard wrote an amicus for the winning side of Garland. but the Garland case essentially basically said that if anybody can, the magic words, ineffective assistance of counsel, boom, there's a conflict, regardless of whether there actually is such a claim or not, a viable claim, and the case gets conflicted out. And obviously, when you've got a case, when you've got substitution of counsel on that basis, then you've got a client who has certain expectations. You know, for one thing, he may think he has an ineffective assistance of counsel claim, when in fact, all he knows is that he lost the case. I mean, which doesn't make the claim. So this is something that this is such a prominent issue in criminal practice, I think is really the fault of the Georgia Supreme Court and their desire to front load ineffective assistance of counsel claims and not defer them to a separate kind of proceeding that is more amenable to that kind of claim, which is habeas corpus. And we don't do that in Georgia because there's no right to counsel. There are a lot of good reasons for not deferring it. But the consequences of actually imposing that issue, which is in a large sense a change of subject, into the criminal appellate process, it's extremely disruptive. And that's really why you all are gathered here. You know, it is so disruptive because we've got, it's essentially requiring the erection of a parallel public defender system, whose only putative function is to look over the shoulder of the poor people in the trenches. You know, and most of the time who have not performed ineffectively. You know, and we're going to have a whole section on this later. I don't want to get too far ahead of it, but the problem is that we just have that claim raised promiscuously, and that it just creates certain problems for us in the field who are stuck with having to do it. One of the great problems being to raise it when it isn't there.
Can